In addition to the classes that you'll be taking looking at substantive law in your first year of law school, you will also be taking a course called Legal Research and Writing. Most often, law schools spread this out over 2 semesters. So, what is legal research and writing? In this video, I'm going to be giving you a brief overview of what the class is like, and I'll give you a couple of tips that I have for succeeding in the course. First thing I want to talk about is what legal research and writing is. The course is oftentimes designed around 2 different ways of writing and researching as a lawyer. Usually in your first semester, you'll be writing what are called advisory memoranda, and you'll be getting introduced to the idea of writing about the law and applying it to specific situations. Think of that semester and think of those assignments as advising clients or advising superior attorneys, people who are going to be asking you for information so they can pass it on to somebody else. And in most cases, you're getting a nice introduction into what it is to be a legal researcher and writer. You'll be introduced to the databases, some of which I highlighted in my video about reading cases, so Westlaw and LexisNexis. And you'll also be introduced to a form of writing called the IRAC method, which I'll be talking about in just a second. Your end result will be a memorandum that will be based around a mock fact pattern that's basically asking you to consider a situation that a client might be going through and applying the law that the professor presents you with to those facts that are laid out in the mock scenario. The second half of legal research and writing oftentimes focuses around advocacy. So instead of just advising somebody, you're also now asking to advocate on behalf of a person you're trying to convince at this point. And usually in that second half, you're taking the skills that you developed in the first part of the course, and you're really ramping those up, trying to develop a clear-cut argument. Instead of being objective and trying to simply advise somebody as to the reality of the law and how it bears on the facts, now you're really looking for the holes in the law, and you're trying to flesh out the ambiguity so that you can convince a tribunal or you can convince another person to go along with your ideas. The end result of that part of LRW will be basically a brief that you would file before a court and an oral argument in which you present some of the information that you have dug up in your research and you presented in your brief to try to convince somebody in a kind of moot court. The goal with LRW is really to give you an introduction. You're not going to be a perfect legal researcher and writer. In fact, many times you're going to learn a lot of the skills that you will be using throughout your career on the job. Most recent graduates of law school really don't do the kind of legal research and writing that lawyers do on a daily basis because they're not under the time pressures and they're not experiencing some of the high stakes risks that a lot of lawyers are experiencing. So it's fine if you leave LRW not being a perfect writer. However, it's really highly recommended to give it your best effort. And so at the end of this video, I'm going to give you some tips as to how you might do that. Now what I want to do is I want to give you an idea as to what the style of writing is that you're going to be doing, not just in LRW, but throughout your legal career. This is just an introduction. I'm not really digging into the nuts and bolts of how you would do this, and it's really one of those learn by doing situations. But at least this will give you an idea as to what the approach really is. The approach is called the IRAC method. This has nothing to do with the country, IRAC. This is really an acronym that stands for Issue, Rule, Application, and Conclusion. I have pulled up here the website for Law School Survival. It's a great website that will give you some tips on how you can get through the first year of law school and to be a success. I'm not necessarily endorsing this website, but I do think it's one that is useful for students. There are other websites like it out there that you should probably look at too to get a nice window or a nice cross-section of what lots of people are recommending with regard to law school. But they have a really good succinct summary of what IRAC really is. IRAC, as I said, is all about issue, rule, analysis, and conclusion, or application is sometimes what the A stands for. There are other forms of IRAC too that might be modified slightly, but generally this is the approach that a lot of lawyers will take when they're actually advising clients and when they're trying to convince somebody to go along with their argument. This is the style that a lot of judges write in too. Law clerks who are writing for judges get used to writing in this way, and judges actually write their opinions in this way. And the reason why it's such a useful tool is because it's very succinct and it's very clear as to how it bears on the facts. Lawyers are all about looking at a situation, analyzing it based on rules, and trying to determine, well, how would we resolve this problem or this issue? So what the issue really is it revolves around the factual scenario. Let's say, for example, somebody comes to you with a breach of contract issue. They thought that they were in a contract with somebody to buy some goods. They exchanged the money for it, but no one ever delivered the goods for them. That's a classic breach of contract situation, and it's one that many lawyers face every single day. So the issue in that case is, was there a breach of contract, or is there an actual claim that is to be made? But within that bigger, broader scenario, there's going to be a lot of facts that bear on whether or not there even was a contract, whether or not the breach actually happened, whether or not there was any kind of injury or damages, and whether or not those damages can be enforced. And each one of those questions is a separate rule. So asking the first question is, did they even have a contract to begin with? That's a subsidiary issue. So you can break down the issue into pieces. And even within those subsidiary issues, you can break it down even further. Was there a signature? Was it a written contract? Was it an oral contract that was given through express or implied verbal or actions? There's lots of different subsidiary issues that are going to come up. And the nice thing is as you break down the factual scenario by those issues, you can isolate distinct questions that you will have to answer. In fact, this is how you should approach your law school exams too. You're going to be faced with one big factual problem, but there's going to be a ton of issues that are buried in there. In fact, when I talk to you about the 1L experience in a separate video, I will go over how those exams are structured and how you might answer those questions. And a lot of it's going to have to do with the IRAC method. So once you've stated the issue and you've made it clear as to what the factual scenario is, you then look to the rules. So what does the law say? And that's where the research comes in. You're going to dig into Westlaw or LexisNexis or some other free source, and you're going to figure out, what does your jurisdiction have to say about this issue? So let's take the question of whether or not there's a contract. Was a contract actually formed? Your jurisdiction is going to have some rules about that. It could come from statutes or it could come from case law. And it will lay out for you what the various test is for determining if there is a contract. What are the various pieces to a contract, and how do we know if a contract is formed? What's the offer? What's the acceptance? What's the consideration that's being given for that contract? And all of those things are going to be rules that you're going to be identifying. The statement of rules is very objective, or at least it is in the advisory memoranda. You're trying to essentially say, all right, what does the law actually look like? And those rules are succinctly stated. You cite to cases, you may quote specific passages of opinions, or you might summarize some opinions through a number of citations. And then those citations are used to essentially build a very large section that lays out point by point how the rule actually bears, or how the rule is actually created. Once you've laid out the rule, then it's just a simple process of applying that rule to the facts. So if the rule essentially says you have to have an offer for a contract, well, now you are looking to the factual scenario. Was there an offer in this person's case? They think that there was. They think there was a contract, but was there? What are the facts that lead you to believe that an offer was actually made? Was there an acceptance? Did the person accept that contract, and how did they do it? Does it fit within the test that the court has come up with, or with what the statute has come up with? And at each stage, you're taking the rules and you're filtering the facts through those rules. It's almost like using a microscope or a magnifying glass. You can think of the factual scenario as the thing that you're trying to analyze, and the magnifying glass or the microscope are a tool, or the rules, essentially, looking through those to try to determine what the facts actually look like. And each time you face a different issue, you're taking some rules and applying those to facts. And the nice thing about IRAC is it's not just the entire memo that's going to be laid out in the IRAC method, but each individual paragraph could be its own IRAC approach. That process of taking issue, looking at rule and analyzing it against the rule. That's what lawyers do every single day. Then finally, you end with a conclusion. Once you've applied the factual scenario to the rules, now it's a simple matter of saying, here's what I think. And in your advisory memoranda, that's an objective answer. You're essentially saying, here's my best guess. Here's my educated hypothesis of this. There may be some problems in it, and I'm going to highlight those problems for you, things we would want to consider, or maybe there's facts that I want to know more about before I reach a definitive conclusion. All of those are objective. And then in your advisory memoranda, you're basically making a good argument. You're saying, look, the rule is clear on some things, but there's some ambiguity in there, and I think it should be coming down this direction. Oftentimes when you're presenting these things to a trial, especially if you're presenting them to an appellate court, the rules may not be totally clear, and there may be a lot of holes that you need to fill. And in fact, that might be what the parties are arguing over, especially if it's really big issues like constitutional issues. And in which case, your job is to take the best view of the rules to this point, lay it out as objectively as you can, and then make a very compelling argument as to how the rules should be diversified or should be expanded in some way. So that's the basic form of the IRAC method. There are a ton of examples out there online, and I have linked to some of those so that you can see what they look like. Law School Survival gives you an example of them, but there are lots of law schools that have web pages with sample versions of this. Some memos are very, very short, isolating one specific issue, and then other memos are very long. In your LRW courses, you'll probably start with a very simple scenario, and then you'll build up to the bigger facts that you're going to look at by the end of the semester. So don't worry if you feel like this is overwhelming right now. The great thing is that's what the whole law school experience is designed to do, and that's what your LRW courses are designed to do. And as I say, when I start talking about the 1L experience, you'll be doing this kind of stuff for exams anyway. So you're going to get in the habit really fast as to how do you use this stuff. Now, the other important part of what you're going to be doing in your LRW classes is you're going to learn the citation system that lawyers use. And that comes from a source called the Bluebook. The Bluebook is produced by Harvard Law School as well as a number of other law schools. And basically, it is a very old system that we've been using for a long time to standardize how we cite to cases and statutes and other sources of law. The Bluebook really is a very elaborate system. This is similar in a lot of ways to things like the MLA style or the APA style that you might have used in your classes. This is not like the Chicago Manual of Style, which is really just telling you how to write and using good grammar and so forth. This is all about how you identify the source that you're citing. And the Bluebook is extraordinarily complicated and complex, and there's lots of different moving pieces to it. In fact, lawyers love to pick out the nitty-gritty. They love to look at the little things that perhaps you might be missing. And legal citations are a classic example of where you can dicker over really, really minor things. At the end of the day, citations really are just trying to aim for helping the person who's reading your opinion to find the source so that they can check it and make sure that you're correct. So your citations need to be accurate and they need to be clear. And the great thing about the Bluebook is if you follow the Bluebook, you're going to be clear. And the nice thing too about the Bluebook is it's standardized across all jurisdictions. Sometimes courts will change slightly. There may be local rules that you'll have to learn for your jurisdiction as to how you cite things within that jurisdiction. But for the most part, every court, every jurisdiction, or every source of law, every tribunal or body that's making decisions about the law is going to expect that you use the citation system. The Bluebook is organized into two parts. There's the blue pages, which are just short summaries. These are the official parts of the Bluebook. They're the ones that are actually laying out the rules pretty succinctly as to how you cite to things like your short form citations, how you cite to quotations, how you use capitalizations, titles, citing to cases, things like that. And the nice thing is it's broken down into individual pieces. The Bluebook, the blue pages are really where you want to look first. That's where you're going to want to actually uncover what it is that the Bluebook is citing to. But then the white pages are an elaboration on that. So once you've looked at the blue pages and you've seen what the citation form is, you can actually go to specific parts of the white pages and see specific instances. So for example, if you want to know how to cite to a decision that's been filed but it hasn't been decided yet, here's how you would do that. If you want to publish or look at an unpublished interim order, here's how you would cite to it. And there are so many different forms of citations that you could get bogged down really fast with them. Someday when you're a practicing lawyer, you will be using this much more so, and you'll get in the habit of just knowing how to do citations. After you've written so many different memos in your life, you will find that you're just reflexively doing this, and over time you're going to get used to it. But LRW is a way in which you can kind of learn this in a very closed system where the stakes are extraordinarily low. And your professors will probably be grading you on that. The other great thing too is your LRW classes will probably have some tutor. This is a person who's maybe a 3L or somebody who's working on a journal, somebody who's done pretty well in law school, and they will be there to guide you on these citations. Most of the professors that you'll be taking LRW from, depending on the law school, will be adjunct professors who are practitioners who don't really have the time to sit down and look over every single one of your citations. So this tutor, this person that's going to be working with the professor, they're going to be the ones actually looking at this. And that's who you're going to want to work with. There's lots of different resources in law school to help you with this. You should not stress about it. My goal here is really just to sketch it out for you. Now, the one nice thing is that the Blue Book, at least in my day, was definitely a written thing. It was an actual blue book that you could thumb through. And you can still purchase the actual Blue Book. In fact, many law schools are probably still requiring you to purchase the actual Blue Book because it's a nice handy resource you can grab and go as needed. But the Blue Book also now is offering this online version of it. You can buy the Blue Book itself, and then you can get a key that will give you access to this online stuff. And it's a really easy, interactive way of finding things quickly. Personally, I prefer the hard copy. I got used to using the hard copy early on in my career, and I've never stopped using it. My copy is very well worn. Sometimes new editions come out, so you want to keep up with the current edition. But again, this is all stuff that that's going to be discussed much more in your LRW courses, and I'm just giving you a brief sketch right now. So now what I would like to do is I want to talk about tips that I have for succeeding in your LRW program. And this is applicable not just to the first semester, but across multiple semesters. And these are good tips that you should be getting in the habit of doing even when you're a practicing lawyer. It really is what makes you a better writer. The bottom line with all practicing of law is that writing is our primary form of arguing. That's how courts are making their decisions. Oral arguments are important. They definitely help flesh out specific questions that a judge might have, especially if you haven't answered those in your briefs. But by and large, lawyers love a record, and they love written records, and clients love to see written stuff because then they can access it later. We want to have stuff written down so that we can access it and that it's official. So the vast majority of what you're going to be doing as a lawyer is you're going to be producing written information. So learning how to write correctly is very much key. The first thing and the most important thing that I think any lawyer or any law student needs to get is something that I talked about a little bit in terms of succeeding in undergrad. And that is, you have got to be very grammatically correct. And I'm not just talking grammar, but also technicalities, writing persuasively, using good rhetoric, etc. Undergraduate is the time to figure out how to write in a correct way. If you don't know how to do that yet, if you're the type of person that struggles with language, or you struggle with constructing a sentence, or you make routine misspellings, things like that, you really need to fix that right now before you even enter law school, because you don't want to be learning how to write like an intelligent person on the fly. Ultimately, lawyers are sticklers for correctness, and judges are very sticklers for correctness. So if you're making dumb mistakes that most people would not be making in a professional setting, it's going to have an effect on you. It just simply takes the wind out of your sails and makes you look like an amateur. So if you're not a good writer, do the work you need to right now. Take the writing courses, take the courses that are teaching you about grammar and construction, even if you're not an English major. Seek out a tutor, take free courses on Coursera. Practice, practice, practice writing and figure out what it is that you're making mistakes on. There are tons of ways that you can do that in undergraduate, and you should not wait until law school to figure those things out. But then once you actually get into the LRW program, there's a few things to think about in terms of succeeding in that new style of writing. The first of those is to focus on the facts. You should be looking at how the scenario actually plays out for the person that you're analyzing this for. Lawyers, at the end of the day, are working for clients. You are an advocate. You're standing in the position of a client and doing the work that a client would normally be doing on their own, but you're doing it for them because you have the professional know-how. So knowing what the interests of your client are, knowing how the facts played out, are really, really key. The facts oftentimes decide the cases. The rules are out there, and the rules are definitely what they are, but it's the facts that help us figure out whether or not the rules are even applicable to us. And it's really important to get in the habit in your LRW course of knowing what the facts are correctly and finding those specific instances in which maybe the facts have a deep bearing on the issue itself. So being able to really understand how the scenario plays out is key. When I was a practicing lawyer, I saw so many examples of when opposing counsel just simply didn't understand the situation. They thought one thing was going on, but there was plenty of evidence to show that actually they were totally incorrect on matters of fact. They might have been really good lawyers. They might have been able to cite to the correct cases. They might have written a wonderful memorandum or a wonderful brief that was arguing for a motion, but at the end of the day, when they got the facts wrong, they lost 100% of the time. Judges care about it, clients care about it, juries care about it, you should care about it too. The other thing that I would recommend with LRW is you need to learn how to synthesize. And what I mean by synthesize is you're actually constructing a rule that's applicable to your situation. The law is vast. If you were to imagine the law as a landscape, it is huge, the sprawling terrain full of different mountains, peaks, valleys, forests, deserts, oceans, etc. And a person can get lost extremely fast in the law. Once you start messing around on Westlaw and LexisNexis as a first-year law student, you're going to find out really quickly just how vast the law really is. And if you aren't careful, you can get lost quickly in terms of how it's applying to your client. So my highest recommendation is to start with the basics. Start with what the highest court in your jurisdiction is saying. Start with statutes. Start with the treatises that have written on this subject before. Seek out secondary sources that are explaining this kind of stuff. Look to your superiors. Look to the other attorneys that you're working with to help you figure out what their past experiences have told them about this situation. Get some guideposts along the way so you're not getting lost in the terrain. And then once you start finding all of those rules, combine them. Take the quotations from different court cases, from different statutes, and figure out how they relate to one another. So in our scenario that I was constructing earlier, you might have one court that's telling you what an acceptance is in one scenario for a contract, and then you might have a court that is analyzing that same concept of acceptance but in a different factual scenario. Take those two rules, figure out how they relate to one another, and develop a new rule, a combination rule, so to speak. That's the kind of stuff that makes for good lawyering. It's the opportunity to take this chaos and make some sense around it. So get in the habit right now. If you're not used to taking different things and synthesizing them, take some composition courses. Study what synthesization really is. And you'll find that it's actually a pretty easy thing to do once you get in the habit of doing it. The last thing I would recommend when you're doing your LRW courses and when you're writing as a lawyer is to be succinct. That doesn't mean be short. Oftentimes briefs can be very long. Memoranda can be very long, especially if the facts are complex and there's a long history that's involved in the case. There may even be a lot of unsettled law that you're trying to analyze within this. So I'm not suggesting that you need to keep things short, although short oftentimes lines up with succinct. What I mean by succinct is you're not getting into the weeds. You're not being distracted, and you're not distracting others. If you can say it in one sentence, do so. If you can take a whole paragraph and reduce it to a couple of sentences and you lose nothing for the meaning, get in the habit of doing that. Make sure that you're isolating with clarity what things are actually mattering. You are probably used to, as an undergrad, droning on and on in your paragraphs. Most professors don't really pay much attention to that sort of stuff. They really care that you're getting things right more than you're actually styling things correctly. But lawyers do, and judges do care about it, and your law school professors are going to care too. And just simply winding on and on for paragraph after paragraph about things that don't matter, that's a recipe for disaster. Make sure you're also being organized. Organize your thoughts. Don't start a paragraph, for instance, with an introductory sentence and say, this is what this paragraph is going to be about. So, for example, in our contract scenario that we were looking at, you might dedicate a whole paragraph to acceptance. First, acceptance is this, and that's your first sentence of that paragraph, and that's focused on one issue. And then everything in that paragraph is building around that one sentence. Then your second sentence is another part of acceptance, and that paragraph is focused strictly on that introductory sentence. Get in the habit of doing that. Don't separate your paragraphs based around topics. Don't take a topic and spread it around multiple different sentences. Don't wind your way through a paragraph and make your sentences vague and misunderstood. You want to right now get in the habit of being succinct and clear in your writing. Well, I hope this was helpful. I hope it gives you an idea of what LRW is like. Of course, if you have questions, you can always email me. But remember, most of these things you're going to figure out at the time, and this is just a chance to kind of sketch these things out. Good luck in your LRW courses.